Welcome back. A Georgia cold case, more than 2 decades old, is now in front of a jury. Back in 2001, prosecutors say Tara Louise Baker, a first-year University of Georgia law student, was sexually assaulted, stabbed, strangled, and then left for dead inside of her apartment, which was then set on fire. This was a case that had disturbing details gripping that neighborhood. That case went unsolved for 23 years until advances in forensic science led investigators to a DNA match linking Edrick Faust to the crime, who now faces life in prison if convicted. But the defense says that DNA alone isn't enough, arguing there's no proof that actually places Faust inside of Baker's apartment. And they've also pointed jurors back to Baker's boyfriend at the time, Chris Melton, who was once a prime suspect in this crime. Let's take a listen to both sides giving their opening statements this week.
For decades, everyone who loved Tara wanted to know who killed Tara Baker. Ladies and gentlemen, Edrick Faust killed Tara Baker. Edrick Faust sexually assaulted Tara Baker. Edrick Faust set her house on fire.
You'll learn the lead investigator in this case, Elizabeth Bigham, told Chris Melton it was okay if he changed his story or changed his timeline of when he was with Miss Baker. And if he admitted to lying to police for 23 years so that she could explain away his DNA and put the focus on Mr. Faust and the responsibility for Miss Baker's murder on Mr. Faust, everything would be okay. She would explain it away. The allure of being a hero, the allure of being on TV, being the officer to solve the 23-year-old Tara Baker case became too strong. The allure of being on TV became more powerful than following the evidence.
We are in the first week of this trial, again, 23 years after the crime. So let's get into the most compelling evidence that jurors have seen so far, beginning with the crime scene photos showing damage to the front door of Tara Baker's home, signaling to the possibility of a forced entry. Now, also during the prosecutors' openings, they said it had never been confirmed exactly how the killer entered her home. The defense brought up this other image of a bent window frame during their openings at Tara's home. Since this was shown during openings, of course, it has not been admitted as evidence yet. But both of these pointing to what the scene looked like, and these jurors are taking that in. Let's bring in our guest panel. We have with us Madeline Somerville, Bob Bianchi, and Philip Dubé. Bob, let me start with you on this one. This is a cold case turned into a hot trial that is happening now in front of this jury in the same jurisdiction where perhaps some of them remember when this happened.
Yeah, so, you know, so many cases that were cold cases. I remember it goes back to when I first started doing homicide work. We didn't have DNA, computers, or phones. I wonder, how did we ever solve a crime? But we did, and we got convictions. And now that old school stuff wasn't able to work in this particular case, but decades later, with the refinement of DNA evidence, we now have a new batch of cases that are solving otherwise cold cases, as we call them. The thing with this case that struck me is that the DNA, at least as I understand it, is coming from the genital area of the victim. And the first thing that struck me is, well, that can be explained by a lot of things, including consensual sex. So I am interested in listening to whether or not they're going to be able to have any medical doctors that are going to talk about forcible injuries to this woman in that particular area, as opposed to casual sex, which could be in a wide range of a time period when somebody may have semen inside of them, not necessarily at the time of the crime. That's the first thing that struck me. Second thing, I'll leave the rest of the guests, is that there was also hairs found in her hand. Now, that's typically something we want to look at. We actually bag the hands in a homicide case because we know that there's fingernail scrapings. Usually when people are scratching, we have hair in their hands. It's what we call trace evidence. The trace evidence, as I understand it, the hair, which is really important to me, came back to a white person, to an African-American. That is very, I'm going to be interested to see how they're getting around that.
Philip Dubé, your opinion of this case and that evidence that we just showed of that potential forced entry inside of the home.
I think the reason why it went cold is because they did not have a forensic match to the sample that was recovered by the SART nurse, the sexual assault response team nurse. So what that means is they entered the specimen into CODIS, the combined DNA index system, and there was no hit. So what happens? Well, the case goes cold. They don't know who that DNA belongs to. But unbeknownst to everybody, this man got arrested several weeks after this homicide, and the DNA was entered into CODIS. The problem was nobody did a check. Nobody ran the DNA from the rape kit. Instead, it sat cold until the Coleman-Baker Act was passed in Georgia, signed by Governor Brian Kemp into law. And it forced law enforcement to reopen these cold cases, run the specimens then through the database, and lo and behold, they got a hit. So what I think probably happened is they sat him down in an interrogation room. He said he has no idea who she is, and they never made whoopee. Well, if that's the case, how does he explain how his DNA got on the young girl? And I have a feeling that a statement is going to be coming into evidence at trial.
Madeline, jump in
lots
here.
of people
We've got that evidence, but we've also got a situation where because of a law in Georgia named for our victim here, that's why they were re-examining these cases.
Yeah, so one issue that's inherently going to crop up when you have cold cases and you're going back and looking at them is chain of custody of the evidence, and it's going to happen in all of these cases. And I thought I might share a story about when I was interning for a judge when she was working in Superior Criminal Court 1, and then she got moved up to the federal court. She was presiding over a rape trial, and it was the first one I had ever sat in on. And the lawyer was insanely good, and he argued chain of custody, and he was acquitted. Come to find out after the trial, this particular defendant had already been convicted twice of rape and was about to be on trial for another one. And it just goes to show it's so interesting that in our jury system, you're not allowed to talk about past crimes, or in this case, it's interesting because he was arrested shortly thereafter. I don't know for what in this particular instance, but I think you examine each case individually. And if you're trying to argue chain of custody, it can be incredibly successful. You could be a guilty person, but they didn't treat the evidence correctly, and you can walk.
Well, you can imagine if this defense has that information, they will be using it. Let's move to another piece of evidence that was shown today that had the defense upset. This is a sketch from 2001. It was drawn by a sketch artist for police based off a woman's description. So she was a neighbor of the victim, and she said she saw a man, quote, acting suspiciously in the area around Baker's apartment when they believe she was murdered. And this witness was Karen Williams. She took the stand today, and during cross-examination, she said she didn't see the man try to avoid being seen or running. So she testified today, but then there was a mistrial request from the defense over her testimony because something she said today on the stand conflicted with what she told police back in 2001. Bob Bianchi, really quick, if you'll react to sketch artists and the weight of that in a court of law. We also have a look at what the defendant looked like back in 2001 compared to that sketch.
All right, so all I'm going to say is that the thing that struck me when I saw that was that this is such an antiquated tool that this may actually throw the jury off of the prosecution. I know that they think it may be a good thing. I just don't see the value of this evidence. I'm not sure. The fact that he's even in the area doesn't mean that, and the fact that he had sex with her doesn't mean he's the person who murdered her and set the fire. So I really don't know how the jury's going to see it. Obviously, the defense was upset, made a motion, it was denied. The jury will make its determination. Sketch
artists, Philip DeBay, are they strong? Eyewitness testimony we have here, that's pretty difficult as well.
No, I think it's weak. And if you remember in the Richard Allen prosecution, where the two young girls were killed in Indiana, the judge, Judge Gull, excluded sketch artist evidence because she felt it was too prejudicial. They are not reliable forms of identification. If anything, they help law enforcement find leads and suspects. But to say that that should be used substantively in a criminal trial, I think it tends to mislead juries, and it would be an unfair use of identification evidence, just like the judge did in the Allen case.
And jury consultant Madeline Somerville, how do jurors respond to seeing an artist who took down someone's description as they described it? You know, it's not technology. This is actually someone going based on what someone is telling them.
Well, what's interesting actually about sketches in particular is that juries are very familiar with that as a technology that's used for identification in these types of cases, because we see it on TV all the time. We've seen it for years, even if it's something that we don't use that's very accurate now. And so actually, I think that they would be, I think we shouldn't overestimate the amount of prejudice that would come from them looking at this, because I think they understand we've gotten past it. I think they understand that this is an antiquated thing that we can't trust, that really could be anybody. I mean, look, you know, you look at the screen, it doesn't match. I don't think that I don't think it would unfairly prejudice the jury, but I would certainly argue that because I don't think it's very effective.
All right, we're going to leave it there.